Welcome to the seventh episode of Called to the Bar, International Law Over Drinks, a series of informal conversations about current issues in international law, life in academia, and whatever else is on our mind. In these conversations, we are speaking off the cuff and without the benefit of footnotes, and nothing we say should be taken to have been thoroughly peer-reviewed. I'm Dr. Tamsin Phillipa Paige, Senior Lecturer at Deakin Law School, and I'm joined today by Professor Holly Cullen of the University of Western Australia and Deakin Law School. Today, we are discussing a saga that's gone on for many years, and I like to call it the curious case of Julian Assange. In 2010, Wikileaks co-founded by Julian Assange, published information passed to him by Chelsea Manning, who at the time worked for the US government. The US said that this information was sensitive and created potential national security risks. Also in 2010, in Sweden, sexual assault complaints were made against Assange. The Swedish prosecutor used a European arrest warrant to request the UK to transfer Assange to Sweden for questioning. In 2012, after Assange lost his final appeal challenging the warrant, he entered the Ecuadorian embassy and claimed asylum. He remained there until 2019. We are not yet at 2029, that's my bad, when the Ecuadorian government withdrew asylum and allowed the police to arrest him for bail absconding. He was then transferred to Belmarsh Prison in London. The US have then requested extradition of Assange to face charges of computer hacking and espionage. More legal challenges followed. Finally, in June this year, Assange and the US government reached a plea agreement where he pled guilty to one count under the Espionage Act with a sentence of time served. He then returned to his homeland of Australia. So, Holly, before we get down to sifting through these overlapping and messy legal concepts in what is a really messy and long-running saga, what's your drink?
Well, it's 9:30 here in Western Australia, so I made myself a fresh pot of coffee. We buy our coffee beans from a local deli called Akila Sisters and grind them for each pot. I'm a plunger coffee person rather than an espresso machine person.
Excellent. So, like you, I am drinking coffee. I get my beans from a roaster in Adelaide that I kind of fell in love with when I was there doing my doctoral work, called Patio Coffee. And I'm having their Annabelle blend, which I would say sits somewhere between a blonde roast and a medium roast with notes of almonds and stone fruit through it. And as someone who lived in America, I picked up the horrible habit of making drip filter coffee. And so I've got drip filter black coffee from Patio Coffee. It's delicious.
Yep.
So
I grew up drinking drip filter coffee as well because I grew up in Canada. So I'm with you. And I've just found that plunger coffee makers give us a similar flavor. It's less intense than an espresso machine, and it's easy to move around when you don't know what kind of facilities you're going to have beyond a kettle.
exactly. I wholeheartedly agree. Do love a good French press. And honestly, speaking of Canada, the only thing we're missing to go with our coffees is a box of Timmy's. Do miss that one.
From Tim Tams to Timbits.
Yes. So a fine tradition when people first appear here on the podcast is that we discuss how we got to know each other. So from my memory, first of all, you had the dubious distinction of publishing an article in the same issue of a journal that my first ever article was published in. But we actually properly met through the Australian-New Zealand Society of International Law's Gender and Sexuality and International Law interest group in the hallway conversation sessions that started through the COVID lockdowns in Australia. And then you went on to do some teaching work with me at Deakin, Legal Ethics and Public International Law. Would you like to tell your version of how we became friends?
Well, that's basically it. When we were talking in the hallway conversations, I mentioned that I'd been teaching legal ethics at Murdoch University, and I had done so at UWA as well. And then you came back to me separately and said, hey, I could use an extra marker. It's in the summer. It was when I was not otherwise doing any teaching. So I said, hey, yes. And then we moved on to my tutoring and marking for you in public international law last year. And somewhere in that, we had a conversation where we started talking about my doing a PhD, because I started academia in the early 1990s, where, particularly in Britain, most people had a master's rather than a PhD when they started. And I kind of never got round to doing PhD. But I'd been thinking about it semi-actively for a few years when you raised the possibility, and we put together a project on feminist international litigation strategies, and I am now halfway through my first year under your supervision, along with your colleague Gabrielle Wolf, doing that.
And can I just say that it is an excellent project, and I'm really looking forward to supporting you through that project and seeing where it goes. So Holly, we're speaking to you kind of on a forthcoming Call to the Bar Roadshow episode about how you got into international law. So we'll ask you a different kind of warm-up question, which is, what skill or skills did you learn outside of academia that have been most useful for you inside academia?
Well, like a lot of legal academics, I practiced law, but not for very long. But one skill I picked up that I found very useful in academia and generally in life is how to write a good letter, how to communicate exactly what you want, clearly, succinctly, and in a way that often has a whiff of lawyer brimstone on it that often gets people to do what you want. One of my proudest moments in academia, it was a letter I wrote on behalf of a PhD student, not one of my supervisees, but when I was in one of my universities acting as HDR director, higher degree by research director, and a student was complaining about how her examination had been conducted, and I wrote a letter about it, and I not only got the decision reversed, but I got an apology for it. So the power of a good letter.
It's an underrated skill, I've got to say. All right, shall we get down to the weird world of Julian Assange and what this means for international law? Because when we look at the Assange situation from the outside, it mostly looks about domestic charges and some domestic extradition processes. But there's also issues of diplomatic premises, of protection of citizens abroad, and the treaties that govern all these extradition processes. So, Holly, what does this whole Assange saga mean for international law?
Well, there are a lot of factors that make it a bit of a unicorn, but there are some important human rights issues that were raised and unfortunately not fully resolved. Unfortunately for the law, fortunately for Mr. Assange, he's home and with his family, and for him, that's a great result. But one of the issues that was still being litigated in the UK, and which was going to be heard, in fact, the first day of hearings on his appeal would have been today, is whether a potential violation of freedom of expression can be a bar to extradition. If you look at the case law, particularly in the European Convention on Human Rights, you see that risk of death penalty, risk of whole of life sentence, risk of torture in the criminal justice process are all things where the court will say, no, you can't, X country, you cannot extradite to Y country because you are creating a risk for this person. There's a little bit on fair trial as well, particularly when it interacts with torture in the sense of there's a risk of evidence obtained using torture being used. But for somebody to say there's a risk to my freedom of expression if I'm extradited, because I won't be able to fully argue that issue before the courts of the requesting country, that is new. And again, because the Assange case is a bit of a unicorn, I can't see that coming up again soon. So that's an issue we won't really be able to resolve. Another issue that the Assange team regards as resolved, but I think is still open, and as do a lot of people, is the question of whether his time in the Ecuadorian embassy can be described as arbitrary detention. In 2016, the Working Group on Arbitrary Detention at the UN, following an application by Assange's lawyers, ruled that he was arbitrarily detained, although there was unusually, it was only 3 members of the working group that made this decision, because one member had to recuse herself because she was Australian and therefore same nationality as the complainant, and one member of the working group dissented. So they said that they treated the entire period from his first arrest up to the moment they were deciding as a period of detention. And I think they kind of confused arbitrariness and proportionality. And certainly anybody who's done admin law will know that those are 2 very different concepts. So they ruled that he'd been arbitrarily detained because he'd been detained for so long, and he had not had a review of his detention, obviously, since he'd been in the Ecuadorian embassy, whereas the British and Swedish governments, who were the respondents to the complaint, never accepted that ruling. And what I think is more relevant is I haven't seen another case like that on arbitrary detention. Arbitrary detention cases are usually detention without legal basis or detention without due process. Usually when you get into proportionality issues, that starts to bleed into fair trial.
Yeah, so I kind of picking up on this, my understanding, and I'm not an expert in this issue, it's why we're chatting with you, is that he went there voluntarily and voluntarily didn't leave there until Ecuador kicked him out. How did they decide that that met an arbitrary detention threshold? Because for me, it seems more like a voluntary asylum seeking situation rather than an arbitrary detention situation.
Well, the critics of the working group decision tend to say, well, first of all, you didn't evaluate his role in his situation. And secondly, that, as I said before, the working group merged a lot of different things. So the period when he was under house arrest with an electronic tag on him, and the period when he was voluntarily in the Ecuadorian embassy. Very nicely, and I suspect with legal advice, Deputy Prime Minister Richard Marles last week referred to the period in the Ecuadorian embassy as confinement rather than detention. Confinement is just a word. Detention is a legal term, and I imagine he may have workshopped what he could say. And even and unsurprisingly, the American court that ratified the plea deal, when they were deciding how long he had served in prison, said, we're only going to look at the 62 months you were in Belmarsh, which is long enough. Of course, COVID happened shortly after he was arrested by the Metropolitan Police in 2019, about less than a year afterwards, before his hearings had started, and that delayed everything. So he has been detained in Belmarsh for a very substantial period of time. But the US court said, we're only going to look at that. And they did describe the whole period as an ordeal. But again, that's not a legally significant word. So a lot of people either avoid the issue by using a term that's not legally significant, or they make clear that they disagree with it. The Assange people continue to claim that the working group on arbitrary detention got it right.
Okay, so noting that you've worked on this a fair bit, what's your position on how we classify that time in the Ecuadorian embassy?
I don't think it's arbitrary detention. I think, as I say, this is a bit of an unusual decision. It's not really consistent with Certainly the European Court of Human Rights case law on Article 5, which is there, the right not to be arbitrarily detained, which again, as I say, tends to focus on legal basis or due process rather than whether it is disproportionate in some way.
Okay, so what happened to that European arrest warrant from the Swedes through all of this? Because we've gone from fleeing into the Ecuadorian embassy for diplomatic protection and asylum to avoid extradition to Sweden, through all this to a plea bargain with the US. I'm confused about the jurisdiction here and who's claiming what jurisdiction and what happened with all of this, because I don't even know who's got jurisdiction over any of this at this stage in relation to it all.
Okay, simply the Swedish situation, there's no issue about jurisdiction. The alleged events happened in Sweden. So it's territorial jurisdiction, that's fine. What happened after Assange went into the embassy was that, well, nothing could happen. They couldn't progress the case any further. And of course, this was a warrant for him to come and be interrogated, not a warrant for prosecution. Formal charges were never laid. The Assange people offered to have him answer questions remotely, but that was declined by the Swedish prosecutor. Over time, many of the charges against him became time barred. So by 2019, there was only one charge left that wasn't time barred. The Swedish prosecutor went back to the courts in Sweden and said, can we have a fresh warrant? And the court said, although it's not formally time barred, so much time has passed, we don't really think it's a good idea to proceed. So that's Sweden. Sweden's off the table now. And the process there is actually fairly straightforward. Now, in his resistance to the European arrest warrant, one thing that Assange claimed was that he was afraid if he would be extradited to Sweden, the US would request extradition from there. Now, I don't doubt the sincerity of that claim, but it's always seemed to me that given that the US-UK extradition treaty, the current one, was drafted in the aftermath of 9/11 and is very favorable to the US, it is easier to extradite someone from the UK to the US than from the US to the UK under this treaty. So if I were afraid of being extradited, I'd be more afraid of being extradited from the UK than from Sweden. And lo and behold, once he exits the embassy, the US makes an extradition request from the UK government. And so since 2019, we've been working through that. Now, the question of jurisdiction is interesting and hasn't actually been explored that much. So going through the possible grounds of jurisdiction under international law, territorial jurisdiction is tenuous at best, I think, because Assange was never in the US during any of this process, and you would have to regard him simply receiving and publishing the information as a crime, which to some extent they did. And so I'm not sure where you get, unless you, because even if you say, well, Chelsea Manning giving him the documents happened in the US, but they're not charging her. So that's all, she's gone through a separate process, been convicted and pardoned or had her sentence commuted. So I don't see how you get a territorial claim against Assange. He's obviously not a US national. Passive personality, the nationality of the victim, well, in the court proceedings ratifying the plea agreement, the US government acknowledged that they had found no individuals who were harmed by Assange's acts, and therefore they were not claiming reparations. So clearly there are no American victims that they can put forward and say, we're claiming on that basis. So it seems to me the only basis on which the US could be claiming jurisdiction is on the protective principle, so that it's one of their fundamental interests that's being challenged. And the fact that they have always emphasized first actual and then later potential, when they failed to come up with any of these actual victims, risk to national security, that seems to be the basis on which they are claiming, but they've never said in so many words.
Okay, so they've never said the sort of protective national security protective principle basis of jurisdiction. And generally speaking, protective principle is a fairly tenuous jurisdictional claim in international law, is it not?
It's not one of the most common claims. Usually, the vast majority of claims of exercises of jurisdiction are either on the basis of territory or nationality. I mean, the Rome Statute for the International Criminal Court only provides for jurisdiction based on the crimes happened in the state, or the person is a national of that state. So and it certainly isn't a universal jurisdiction claim. It's not the type of offense that usually universal jurisdiction is claimed over. So there aren't that many cases where the protective principle has been clearly claimed. But
okay.
I think the US is one of the countries that is more likely to make such claims.
Fair. Okay, so what I'm understanding of this whole process is that this entire process came about through a very convoluted attempt to avoid answering questions around sexual assault, and it's turned into a massive multi-state diplomatic incident.
Well, yes, but there's always been the background of concern about being prosecuted by the US, because they've always taken the view that what Assange did in publishing all of this material was criminal.
True. Yes, it has always been there. So let's look at the diplomatic premises and diplomatic protection thing. So he hid in this Ecuadorian embassy, and he didn't get picked up until the Ecuadorians threw him out. What does this say? This seems to me to say very good things for respect for the inviolability of diplomatic premises and the Vienna Convention on Diplomatic and Consular Relations, I think it's called. But talk us through that, would you, if you don't mind?
Okay, so it's the Vienna Convention on Diplomatic Relations that would be relevant here. And yes, the UK never suggested that they would go in. They had, while I think they had police regularly posted outside there in case he tried to step out for a cigarette break or something, but they never did that. And the UK, there's a previous example in the UK of very strong respect for diplomatic premises under very high pressure in the 1980s, when outside the Libyan embassy there were protesters, and of course there were police keeping the protesters from doing anything too worrying, and a police constable was shot from within the Libyan embassy. So the UK requested that the person who'd made the shot be surrendered to them, but that didn't happen. And in the end, they just let the Libyans pack up the embassy and everybody went back. So I think whatever else we can criticize the UK government about in this or any other incident, they have twice demonstrated that they take the inviolability of diplomatic premises really seriously.
Yeah, which ironically, the Ecuadorians are not right now. Is that the case?
Yes, the most recent case to be application to be made before the International Court of Justice is a case between Ecuador and Mexico, where an Ecuadorian politician sought and was given asylum in the Mexican embassy, and the Ecuadorians wanted that person out and were perhaps a little bit less and at that point weren't saying, oh well, too bad, he's in the embassy, he's been given asylum, inviolability of premises, too bad, so sad. They were very angry and seem to have forgotten that they relied on inviolability themselves not that long ago.
And that's currently before the ICJ, is it not, that case?
Very early stages. The application was April 29th of this year.
So hopefully we'll get Juliet, another member of the Call to the Bar team, live tweeting that one when it finally gets through the ICJ argument stage, given in her procedure goblin persona. I
look forward to it.
Any predictions on how that's going to play out, given that this history of relying upon inviolability of diplomatic premises from Ecuador? Recent history at that.
I think the practice of the ICJ is to enforce diplomatic immunities very strongly. Going back even to the case of the American diplomats held in Tehran after the revolution. So the ICJ has a pretty strong record, again, on upholding diplomatic immunities, including inviolability of premises. And I think that that's right, because these are some of the oldest international law rules out there. They have roots in the ancient world. So I would be surprised if the ICJ did anything other than basically read out the relevant provision of the Vienna Convention on Diplomatic Relations and say, that's your law.
Let's hope. So within all of this, the one thing that's been absent from our conversation is what was Australia doing about Assange? And we don't necessarily need to go into the factual side of it, but what was Australia's obligations under international law towards Assange in terms of protection of citizens abroad and all of these other things? Because there's been a lot of criticism of numerous Australian governments on either side of the aisle for not doing enough to support Assange. So what was Australia required to be doing in this, and how did that stack up against what they did or didn't do?
Well, diplomatic protection is a right of states rather than of individuals. So a state has the right to take up the claim of one of its nationals and either litigate or make a claim in diplomatic fora for the rights of that person. And increasingly, that's a big part of what embassies do. There are, according to the last consular state of play, in each of the last 5 years that the Department for Foreign Affairs and Trade has reported on, which only takes us up to the middle of 2023, there have been at least 300 Australians imprisoned abroad. So Assange, again, is the tip of an iceberg of lots of other people in various countries and various situations. So if we go back to 2010, 2010 to 2012, when Assange was fighting the European arrest warrant, there was a tendency to say, we're not going to interfere in British legal processes. British legal processes are, it's a mature rule of law state with a Human Rights Act, which is more than Australia has. So, and access to the European Court of Human Rights at the end of it all, if they want. So we're just going to let that roll on and reach its natural conclusion. And to some extent, that was the same thing that happened for most of the time with the extradition process as well. There was a tendency to say, we're not going to interfere in foreign legal processes, and we have every reason to respect the UK processes. During the period where Assange was in the embassy, there was a tendency to say, we offer consular support. In other words, you can talk to somebody, but over various there were various periods of time when Assange refused consular protection. So particularly around 2019, when he was first imprisoned in Belmarsh, for a while then he basically, the British High Commission would say, we'll have somebody come and talk to you, make sure you have everything you need, etc. And he declined. But again, at that point, what they were offering wasn't very much. Now, what happened, I think a bit of a tipping point for the politics in Australia, because although you see a buildup of support on both sides of the House for Assange over time, more and more MPs saying, we support Assange, we think he shouldn't be prosecuted, he should be released to come back to Australia. But the tipping point, I think, was the January 2021 district court decision in England, where the judge there said, I think that extraditing Assange to the US would be oppressive because of the prison conditions that he would be likely to be held under, and because given his profile and medical evidence that was submitted, the judge thought that he would be a high risk of attempting and suicide and probably succeeding. So at that point, you see the leadership of the Labour Party, which was then in opposition, saying, this has gone on long enough. Enough is enough. There's no interest served in continuing to do that. So once there was a judgment, although it was reversed on appeal, that said that the extradition is problematic, the higher profile political actors, I think, felt that they had cover, and that was maintained over time. I also believe that Assange's father was living in Anthony Albanese's constituency and had met with him personally. So Albanese took this up as a representation of his constituent.
Okay, so we have all of that as what they can do, but from a legal point of view, they weren't really obligated to do anything in particular for the citizen abroad, and it was all kind of at the state's discretion, is my understanding of where we're at in terms of legal obligation, the international law around this.
Yes. If you look at the draft articles on diplomatic protection, which were drafted to reflect the customary international law on this, there is no obligation to pursue this. The Article 19 of the draft articles recommends that individuals be involved in the state's processes for diplomatic protection, but the international law is pretty clear on this. There are some individual countries where, as a matter of domestic law, either there's an obligation to support citizens abroad, or is at least it's a reviewable decision in domestic administrative law. But in international law, diplomatic protection, as it's called, is a discretion of states, and it's a right of states, and therefore they can choose not to exercise it.
Fantastic. So despite the fact that the situation is a political mess, the only real question that hangs over all of it, well, there were two real questions that were unresolved. First of all, is the US basis of jurisdiction is deeply unclear and potentially problematic in terms of an extraterritorial jurisdictional claim on the protective principle. And also, the other question is whether or not being trapped in an embassy as a matter of diplomatic protection and asylum constitutes an arbitrary detention, which is still a live issue that we may never get resolved.
Yeah, that, and whether a claim of freedom of expression is a strong enough human rights claim that a court like the European Court of Human Rights would say it's a bar.
A bar to an extradition process. So, yeah, but that, thank you. That kind of wraps up the main topic for today in terms of what does this mean for international law? And it means we're seeing a continued respect for the inviolability of diplomatic premises, and we have a whole heap of questions around human rights and extradition and around US claims of jurisdiction.
Yes, I think the general view was that although the plea agreement was a good result for Assange personally, that it wasn't a good result overall because it established a practical, if not a judicial, precedent of prosecuting for the publication of information as espionage.
Okay, well, I doubt we'll get that resolved because the saga has been put to bed now after 14 years, but that at least gives us a good overview of the international legal issues at play.
Okay, well, I think it's my turn to ask you a question. And now your PhD and master's research was on piracy and then on the UN Security Council. But in recent years, you seem to be emerging as a real authority in Australian international law on queer approaches to international law. So how did this happen, and why do you think that's important?
Let's answer it backwards in that why is it important? Because the whole base premise of queer theory, be it in international law, but particularly when we bring it to international law, is the questioning of the assumptions that is being brought to the law through this, as Diotto put it, as curiosity and play, this sense of coming to the law and going, well, what assumptions are we bringing to the law, and are they valid or helpful, and trying to change that perspective and see how that changes how we interpret the law. So I think it's really important field of study going on here, and it's also bigger than just looking at queer lives. A lot of my stuff does focus on queer lives, and we'll get to why when we get to the other part of the question. But if we look at some of the other people who are working in this space, like Emily Jones, who's looking at environmental law and questions around how we understand law beyond humanity, or Gina Heathcote, who's been doing some work on queer oceans law and law of the sea through a queer perspective. Claire Wynne O'Hara, my dear friend, and they've done some work on queer economic law, but also queer space law. And so there's this whole idea that the real founding premise of queer theory, which I would argue is a subset of feminist theory, is all about challenging the assumptions that we carry to law, which are often very heteronormative and patriarchal. And that question of patriarchy in international law goes right back to the wonderful 1990 paper by Hilary Charlesworth and Christine Chinkin and Shelley Wright on feminist international law. So it's continuing that process of fighting for equality in how we look at the law, but also doing it through getting people to attend to their assumptions that they're bringing to the law. How did I get into this position and space? Mostly by accident, kind of reluctantly, which was silly. In hindsight was silly, but it kind of started when I was working on the women, peace and security agenda stuff and how we got in the women, peace and security agenda and whether or not issues of the women, peace and security agenda could be considered a threat to the peace, leading to Chapter 7 style decisions by the Security Council and thus binding law. And what I got to at the end of reading all those transcripts was a deep-seated anger at how all of the P5 treated armed conflict sexual violence as a man who was a direct participant to hostilities engaging in sexual assault of a woman who was a civilian. And that's the most common dynamic, not arguing that. That is the most common dynamic. But they were only speaking about that binary in spite of evidence tabled in meetings that showed how much bigger the problem was than that. And it made me really angry at the silencing of the voices of victims, often who were men being raped by other men, men being raped by women, as we saw very publicly in the Abu Ghraib reports, among other places, and going through all of this and looking at the victims whose voices were being erased by only focusing on that binary. It just so happened as I was doing that, Professor Diane Otto, who's at Melbourne University and one of the pioneers alongside Wayne Morgan at ANU of queer theory and international law, emailed me to ask me to write a chapter for a book on queering international law. And I went, you know what, actually, I'm really angry about this. I can write that chapter. And it kind of blossomed from there, despite the fact that at the time I was very reluctant to move into working on these spaces of queer lives and queer theory because I didn't want to get pigeonholed as the queer scholar working on queer issues. In hindsight, if you read my piracy work and you read my Security Council work, it's underpinned by queer theory as a method and approach. I just wasn't overt about it. And as I felt more comfortable and secure in my position in academia, I felt safer to come out and advocate for these issues through queer work.
Well, that's one, when you were talking about looking back at your work and seeing that even when you weren't writing about queer lives, you were still using queer approaches, is something that I think resonates with some of the things I'm doing with my PhD in terms of saying, well, let's look at something like climate change litigation, and even where there aren't feminist groups, although there are in some of these places, that you can look at this through a feminist lens because some of the ideas from feminist and queer theory are present in the way that networks and communities are built to bring these cases and to argue them. And I think so I'm learning a lot from you on that.
Thank you. And yeah, like queer theory and feminist theory at its core is about equality. And if your equality is not equality for everyone, then your feminist theory isn't worth the paper it's written on, as far as I'm concerned. Yeah, it's a bigger issue than feminism is not just about issues for women. It's about equality, often with a focus on women's equality, but it's about equality for everyone. And that's really important because if it's not equality for everyone, then it's not equality. We are coming to the end of our time, so I'm going to ask a couple of wrap-up questions of you, Holly. What recommendations do you have for anyone who'd like to know more about what we've discussed today?
Well, I've written a series of short pieces for the conversation on the various legal issues around Assange, and I provide links for those, and those are like 1,000, 1,500 words at a time, so they're quite digestible chunks. I would also, there's a chapter in a book I edited, the chapter written by Suzanne Akila about the Legrand case, which I think is quite a good piece, one of the best pieces I've seen recently on diplomatic and consular protection and how to understand that in a broader context. And I think that there are a lot of echoes with what went down with Assange.
Fantastic. And finally, if you weren't an academic, what would you be?
In terms of the skills I have, I think I would probably be working in some kind of research or campaigning capacity. In the last few years, I've done quite a few submissions to inquiries that I think have been well received, in some circumstances influential, and I think that that's a skill I could offer. If I was going to walk away from anything of that, I did at one point consider retraining as a barista.
Fair enough. And who doesn't love a good coffee?
Exactly.
Right.
You're one of the most popular people in the community if you're a barista.
Pretty much. Thank you so much for joining us for this episode on Julian Assange and extradition and human rights. Yeah, we look forward to possibly seeing you again on Call to the Bar in the future.
Thanks. Been a pleasure.